All right. Good afternoon or good morning, everyone. This is Curt Verone, and I have my my pinch hitting colleague, Bill Maccarone. Bill, welcome. And
Thank you
we're
for
here.
having me.
Yeah, well, we're here for another edition of Fire Law Roundup. Let me just do this. All right, and we got that silenced. Brad, I'm not even sure where Brad is. He just said that he's traveling. I know that, and I texted him a couple of points last night, and he was not able to get back to me right away. But so I know he's traveling, but I'm not sure where. So
I'm sure it's somewhere with palm trees or something like that.
knowing
Palm
Brad,
trees are in the background. Or
well, I don't think he went up to up to Alaska to go snowmobiling. So that'd be my bet. But I think he may actually be lecturing. So I think that's where the trip was. So
okay.
at any rate, Bill is here, and we're gonna get into this week's 5 cases. And Bill, are you familiar enough with the cases? I know I wrote them, but I didn't know if you feel comfortable. Go ahead and
I'll get it started. We'll start for like the case that you blogged about last night, and had a complaint in California state court. A battalion chief from Sacramento, so city of Sacramento, claiming race discrimination and retaliation. And it looks like from the face, obviously it's the complaint, so it's the allegations that the chief is making at this point. It looks as if almost a situation where the chief was consistently turned down for promotion, couldn't make it to the higher, deputy chief type of a position, up from the BC position to a higher ranking position. And it looks as if his claims, at least he's saying that there was he had at least I don't know if he had testified or if he had supported a victim in the past that was alleging discrimination.
Interesting. There's actually 2 cases that one was a white firefighter who was, according to the complaint, was falsely or inappropriately accused of doing something wrong, and he testified in favor of that firefighter. I'm not sure why that would have gotten him in trouble. That wasn't clear from the complaint, but at any rate, he says that he testified in support, and that sort of brought him the ire of his bosses. And then there was another situation where a female, apparently a captain, and again, kind of hard to understand from the complaint, but a captain kicked the turnout gear of a female firefighter, and I forget the term, but something like in a sexually offensive way or whatever. And I'm not sure how you kick turnout gear in a, maybe the motivation was gender based, but at any rate, he escalated that complaint. The complaint was brought to him as a battalion chief, and apparently the department supervisors, according to the complaint again, sort of resented the fact that he did that. And then he also said that one of his superiors in the office, referred to him as a cancer in the department. And apparently that got back to him. I don't think they referred to him directly as that, but they made that comment. And so the allegation here is that he's the victim of race discrimination, that he was passed over twice for promotion to deputy chief, where according to him he was more qualified than the folks, the Caucasians that were promoted.
One thing I thought was interesting, and I want to get your take on this, it was the case was filed. Typically, your discrimination lawsuits are going to be filed in federal court.
Right.
Here, it was filed in state court, and it was basically it's citing the California government code, which we both know California has some pretty stringent labor-related, labor type laws on the books. Do you have any indicate why would they do that? Do you think?
Well, there's a strategic reason. Some attorneys like you and I mean, I'm more comfortable in state court. I've been to federal court. It's not where I would choose to go. Some attorneys would prefer to stay in state court. Some attorneys would prefer to go to federal court. But if you make a claim in state court and you include any federal allegations in it, the other side then can remove it to federal court. And so I think that by staying with just the state law claims, because race discrimination and gender discrimination, all of those are going to violate both state and federal law. So if you file a lawsuit strictly under state law, you're probably going to stay in state court. So, and there may be some favorable interpretations under state law I know New York and California kind of have a reputation on sexual harassment in particular of going beyond what protections the federal law has. So there may be there's no doubt strategic reasons why they did that.
Yeah.
Right. We always get accused. It's funny. We always get accused as attorneys of shotgun and what do you call it? Complaint drafting, right? You know, and going after everything. So you'd include your state law and your federal law.
Yeah.
You know, in real life, I don't think that happens all that often. Shotgun pleading, that's what they call it, shotgun pleading. And my sense is the attorney here definitely wants to keep it in state court. There's no other reason.
I have to. Yeah, absolutely.
So, but interesting case. We'll see it. I know there was some, media attention surrounding this case, and apparently there had been a couple of others with allegations. This one I really thought was kind of light in terms of the allegations. I don't know what your sense was.
No, it was. I agree. And I think one thing, when I was reading the complaint last night, I was going through the complaint, and obviously we'll see if maybe, and I don't know if this is if maybe the hurdle, maybe in the state court, there's a little bit of a different analysis when you get to that summary judgment stage, possibly. I don't know. And that's obviously, I'm not familiar with California, law, but that could be a possibility too, I suppose.
Yeah. And, some attorneys tend to load up factual allegations in their complaint, and some attorneys don't. And it could very well be that the attorneys here opted not to include all of the individual factual allegations. But I know if you compare this complaint to several of the others that we have had, through the blog, you'll see that many of them have a much more detailed and many more factual allegations than what we see in this one. So we'll see. That was interesting too, that they're going after the department for failing to take adequate precautions in advance of this, such as training and supervising the officers to make sure that they're complying with the law. Again, I'm not familiar with the particular California government code that's cited here, but I do know when it comes to gender discrimination, California and New York, have those additional requirements. I know New York has an annual requirement. I'm pretty sure California does too. You've got to do annual sexual harassment training and so on. It may extend to other types of diversity type training as well. And so it could be that, embedded in the allegations there are some things that would be unique in California. Yeah. So
that was a good point. Very good point. All right. If we want to move to the next one, if we're ready. There's another
battalion chief.
Another battalion chief. This one out of Florida. We're going from West Coast back to East Coast here. This one, it looks as if it was the court dismissed this battalion chief's lawsuit that was filed. I guess, what was it, 2020? I think it was filed, or it was terminated in 2020 from the Haines City, Florida Fire Department. One thing that struck me here, the battalion chief was terminated, filed a lawsuit, federal court, and the federal court ended up dismissing the lawsuit in this past week or so. And the allegations, correct me if I'm wrong, the allegations that he was making was he was fired in violation of disability laws, and that he had a disability, and as a result of the disability, they should have made an accommodation for him. They should have accommodated this chief in his job.
Yeah, it's a little sort of nuance here. He's alleging retaliation under the Americans with Disabilities Act, but he's also alleging that he was being retaliated against for taking workers' comp. And in most states, the employer cannot retaliate against an employee for taking workers' comp. For example, if you hurt your back, you can't use that as a reason to terminate someone.
Sure.
Okay, or increase scrutiny or whatever it may be. So there's a little bit of a thin line there, but he alleged both workers' comp retaliation and disability discrimination.
And what I found interesting is going through at least what the court found relevant. It seems as if the department did a pretty good job of laying out some non-discriminatory reasons of why they took the action which they took. Like, I think that was one thing, and that's an area that I think fire departments in general, we tend to not do that well. We put the fire out well, we respond to the emergency well, we do all these things well. What do we not do well? We don't do, we're not good at documenting, we're not good at kind of taking things in incremental steps and keeping track of all the activities that occur over a timeline. And it appears as if the department did a really good job in that area, at least in the court believed they did, as far as that's where they found that this lawsuit really didn't have legs.
Yeah, and I think I think anyone who's been in the front office of a fire department has had to deal with these types of things. This was sort of a daily occurrence in Providence, and so you have these types of things coming up, and firefighting, we go to the fire academy, we learn how to do the job, you get assigned to a company, you get experience, you watch other people do it, you do it, and there's a combination of classroom and practical experience. When it comes to handling things like in the front office, there's no classes, there's not a lot of classes on it, so you do what the people before you did. You handle it, and then you handle 100 cases, and you handle it in a certain way. You don't do a lot of documentation, and then all of a sudden you come up with a case like this where there's these allegations. So the reason I'm saying that is my guess is this is not the first time this department has sort of been through the mill, and they documented, they learned over the course of time that you need to document these things and document. They were able to navigate this. If they hit a home run the first time, congrats to them. But very often these types of claims, and I don't want to get into bashing the plaintiff in this case. You can read you read the decision, but he had a number of issues over the time where he apparently didn't want to go to emergencies anymore.
Yeah.
And, that happens to people. I've seen it in my career where folks, they, for whatever reason, he had some, I guess, anxiety issues and some other problems. But at any rate, he claimed that those were disability, and the court was able to kind of get through those allegations and basically say, they had some legitimate reasons for your termination that had nothing to do with your disability. Exactly.
Because when you go to the disability, that's a tough one, because is it a reasonable accommodation? I think the facts kind of led to a time period where this chief was allowed to kind of be second, not responding to calls, which is kind of unusual accommodation for a BC, I would think, I would
think so too.
So, yeah.
Yeah. So, and this is one of those cases, kind of like the opposite of what we just talked about in California. But in California, we talked about it was filed in state court in order to stay in state court.
Yep.
He initially filed in state court, and then they amended the complaint and added some federal allegations to it. So maybe they felt like they needed a little bit more, teeth to the complaint. So they filed an amended complaint which made federal allegations, and then not surprisingly the city turns around and has it removed to federal court, and then it ended up being decided in federal court on the basis that they had a legitimate reason for terminating them. So
all right. Now, this is the one, this to me was the most interesting one of the week. And we've got a couple of FLSA things. So for me to say that, this is big.
Yeah. This is a fascinating case.
Yeah.
This one.
Really very true. I guess May 15th, 2020 will kind of set the stage a little bit. The city of Burlington, Wisconsin, there was a plane crash. A horrible, I guess the pilot was killed, and the pilot was killed in the crash, or a terrible tragedy. For this small plane crash there in Burlington. But as a result of the response, the fire department was responding with apparatus, and apparently there was a private road with a historic bridge, and I guess it was some sort of a truss bridge, and
metal truss with wood decking.
Yeah, and a firefighter drove and a 40,000-pound engine across it and damaged the bridge significantly to the point where it was going to require at least over $100,000 in repairs. And it looks as if it was $100,000, and I think the owner did the repairs himself, and it was $100,000 in materials, and it didn't even look like the labor was included in that $100,000. But what ended up happening, and correct me, Curt, this was just me reading it through it last night and then again this morning. Basically, the city didn't react quick enough in the terms, or at least the homeowner, the bridge owner, didn't think that the city kind of reacted quick enough to get it repaired. Went and did the repairs, and then kind of sued the city for the cost of that.
Mm-hmm. Yeah, I didn't get that out of it. You may have gone a little bit deeper than what I went. All I know is that the bridge owner says it cost me $100,000. Therefore, I want you to pay me $100,000, and the city didn't. So there was a lawsuit, and to try to recoup it, and the lawsuit, as lawsuits tend to do, they drag on, and the meter is running for both sides. But the municipality probably has insurance. I'm assuming they have insurance. So the insurance is, paying the attorney's fees and the costs on the defense side, whereas on the plaintiff side, it's coming out of the plaintiff's pocket. Yeah. And as a result, what eventually happened was they agreed to a settlement on the eve of the trial, and it looks, at least the settlement was around $35,000. And the plaintiff, the owner, the landowner, the bridge owner, I guess they're out more than $35,000 just in legal fees was part of. So I felt bad. The quotes were, we got the landowner, we got railroaded. You work hard, save your money. They come and take it away from you. So it was, like you said, a fascinating, fascinating type of a situation, fascinating case that would end up going to court like that. I think what would be interesting is to kind of give some insight here into the conversation that takes place between the client, in this case, Mr. Bieneman, and Mr. Bieneman's attorney. And the conversation, in my experience, the conversation is going to go something like this. The attorney's going to say, look, you're into me right now about 40,000. Okay. I estimate we can get through the trial in maybe 3 or 4 days. And there might be some motions and some different things and so on. But we're probably looking at another probably 40,000 for the, maybe 30 at the low side to get through the trial, because I've got a lot of prep time. So, if you're prepared for that, then we can do it. If not, they've offered 35,000. Maybe I'll even drop my fee down to 35,000, or maybe not. I don't know. But I think that's probably, this is from the outside looking in. I have no idea if that's actually what's going on. Sure. But very often that conversation has to take place. And I think it's unfortunate. From what I understand, I read another article about this, and the driver, I believe, was disciplined in this. It did say that the driver was released later on, or was let go soon after that. I read the same thing. Yeah. So there was some fault on the part of the driver. Yeah. Okay. Whether or not the bridge cost 100,000, I saw something. So one of the news articles about it said it was actually 200,000, but then that was the only one article that said 200,000. It was a separate article. So I usually I typically go beyond what is in the decision if I can find some other news articles. And one of the articles, it might have been a quote from the gentleman, but at any rate, the case was settled, and it was not settled for what the plaintiff had hoped. No. So again, another lawsuit with no winners. No, very true. No, it's very true. But that was definitely an interesting. I thought that was the most interesting of the of the five. Yep. All right. Well, let's get to the FLSA. There's a couple of lawsuits last week related to the FLSA. You grabbed two of them here. One is this is interesting, North Carolina. Let me try to see what's the Long Creek Volunteer Fire Department.
complaint filed by a former firefighter against a volunteer fire department, so a volunteer fire company, which is very relevant here, obviously, because most likely, at least according to the allegations, it's not going to be a public agency, which we'll touch upon that here for a second. But here, it looks as if this firefighter, the firefighter's name was Jerry Swift, worked a lot of overtime, was working, some of the factual allegations had him working 60, 70, 80 hours a week, and was just paid straight time pay for all of the hours that he worked, according to the complaint. And for folks that are kind of saying, well, wait a minute, what about, 53 hours or a work period? That's the relevance of this being a volunteer fire company. If it is truly a volunteer fire company, which the complaint, they claim it is, there's no 7K exemption. There's no small fire department exemption. You don't get to avail yourself to those special rules in the FLSA that are for the fire departments really only to use.
Yeah, and I just, because some of the folks that listen have been through our FLSA class, so they're going to know exactly what you meant. But just there's a very, very important distinction between, if you're part of government, you're what the FLSA calls a public agency. Yeah. But if you're part of government, and that could be a fire district, it could be a municipal fire department, county fire department, emergency service district, any of those would be public entities, public agencies, and they can get, number one, the 7K exemption, which allows you to go to 53 hours a week before overtime. And Bill mentioned the small fire department. I got a question. Is it the small fire department exemption or exception?
I call it exemption, but I would have to look that one up.
Yeah, I know. But I believe it is exemption. I had to look that up recently, and I'm pretty sure. But my memory being what it is, I would have to go look it up again.
I think it's an exemption,
but bottom line is that the small fire department exemption is, and only Congress and the FLSA can do this. Okay, but you have to have. First of all, you have to be a public agency, and second of all, you have to have less than 5
fewer
employees.
Less than five. Fewer than 5. So what is
you wouldn't say 4 or less. You got to say less than 5 employees in fire protection activities. So the problem here in this case is the Long Creek Volunteer Fire Department, Inc. appears anyway to be in the private sector. Therefore, they can't take advantage of either the small fire department exemption or the 207K exemption, and they've got to pay overtime after 40.
Yeah, it's the kind of the default rule under the FLSA. There's a presumption that all employees are entitled to overtime after working 40 hours every 7 days. Mm-hmm. And there are many, many different exemptions, exceptions, and but the default rule is overtime after 40. And for those private, fire departments, like it appears Long Creek Volunteer Fire Department is, that's where you're stuck.
Yeah. Now there's one more exemption. Okay. Or is it an exception that may apply? Can you think of what it would be?
Oh, the fluctuating work week.
No. We'll talk about fluctuating.
Yeah.
work
Next, what do you?
No. Where I'm going is that total exemption if your budget is less than $500,000. Okay.
Okay.
You follow what I'm saying? So if your budget is less than $500,000, now here's the other side of it. You cannot have responded to anything that is in interstate commerce, which is, I think that's the exception that's going to swallow the rule here, because how can a firefighter do virtually anything without responding to an incident that is, involved in interstate commerce? You go to a post office, federal property right off the bat, highways, even there was an arson case. I remember years ago, we studied this in law school. It was a fire in a pizza place, and the person was charged with a federal charge. The person who set the fire in the pizza place was charged with a federal charge of arson. Okay. So would you think a pizza parlor is in interstate commerce?
I would say no, but What's the
federal
catch?
district court said yes, it was. Yes, it was, because they buy things that are in commerce through interstate commerce. They take credit cards. They do banking. So the pizza business was in interstate commerce. Okay, so it's almost inconceivable that exception that I just spoke about, even though your budget is less than $500,000, is going to apply. Now, it's not to say it can't. You should always consider it, but I think that's about the only defense that I can see for this department.
And it is ironic, because if in fact the FLSA does not apply, and this is just dawning on me now. This is North Carolina, and you remember, you and I have both found some interesting regulations in
that's a polite way of saying it,
from North Carolina that can apply in instances where the FLSA doesn't apply. Typically, that usually the FLSA is your ground floor. Not necessarily in North Carolina. In North Carolina, if the FLSA doesn't apply to you, there are additional regulations that actually bring you below, what the federal does. So that is an interesting thought. I didn't think of that part of it.
Yeah. So, but let's get to your case. And again, here, this is an example where we've got to kind of transition over to Bill's blog. Bill runs firefighterovertime.org. And you hit a really important case out of Los Angeles.
Yeah, this is going to, I think we're going to see more out of this, obviously, because just seeing the way the lawsuit was put together, seeing the classes that are represented in the lawsuit, I think this is going to be a big one. And it's going to answer one of the questions that we've had for a while when we teach our 4-day FLSA class. And that is that kind of commuting from station to station when you're on duty at station 5, and then you're moving to station 6 the next day for an overtime shift, or maybe last night was your overtime shift, you're going to your home station. What's the compensability of that time? And there's a lot of different, really high level continuous work days, a lot of high level FLSA issues that are going to be at play here. But let's just kind of touch upon the lawsuit. The lawsuit was filed. What date was it filed? I think it was the 10th, February 10th, federal court in California. And it's City of Los Angeles. So it's a big, obviously big fire department that is the defendant here. And an interesting thing is the 3 plaintiffs, they kind of, the attorneys, I think, did a really good job of kind of getting 3 different classes of plaintiffs, like 3 different potential plaintiffs. You've got your retiree that recently retired and is saying over the last 3 years, this is what, the FLSA has been violated in the following ways. Then you got the active duty firefighter that's on a 53-hour work week or a 56-hour work week. And then you had 40-hour employees that they kind of were making the same allegations. There was a third party or a third class that was kind of included in there. And the reason for the lawsuit, or the complaint that's being made by these firefighters, is there's 2 basic complaints. First is they're getting held over regularly because, well, let me back up. The City of Los Angeles is a common practice to have early relief, and folks that are in the fire service are familiar with the term early relief and the fact that very often maybe your official shift change time in LA is 8 a.m. but folks start coming in around 6:30 in the morning to relieve the off-going firefighter. So there's a regulation in the FLSA that allows that. That's okay. You're not going to have that. That's not going to be allowed if you work in private industry somewhere. You don't just come in an hour early and the other person goes home, and that's just not how that works in private industry. Here, there is a regulation that allows fire departments to do that. So we have that early relief issue. But what's happening is, because at least according to the complaint, firefighters are consistently coming in early for their relief, and they're consistently getting held over on the back end. So they come in at 6:30 in the morning, relieve, firefighter so-and-so. In theory, 24 hours later, around 6:30 in the morning, firefighter X should be coming in to relieve them, and they kind of go home. And that's how the whole process of early relief works. Here, they're claiming that for a number of reasons, that's not happening. And the main reason, the 2 reasons that they're citing are the amount of overtime. It's taking firefighters quite a while to get from station A to station B. And there's so much overtime that there's frequent instances where firefighters are being held beyond that early relief time, and they're not getting compensated for that, whether it be 45 minutes or an hour at times. And obviously commuting in LA is far different than commuting in many organizations, where typically for me to go from station 5 to station 6, I'm looking at like 15 minutes, 12 minutes, something like that to kind of make the trip. Here, you're going across Los Angeles,
LA
it's 45
traffic,
minutes.
it's legendary.
Yeah, so the claim is that this is not uncommon for these folks to be held, significantly 45 minutes, an hour beyond their normally scheduled time would they be leaving. So that's interesting, but I think the most interesting, or the one that's really going to be, I think it's going to sting, personally, I think it's going to sting, is the city has a practice called, I think it's the recall. And what the city does, and I get this, I totally get this. I've had to do this on in my job day to day. You get a couple of people out in the morning, and I'm managing a shift of 20. And this is, these folks are managing,
2,000.
enormous numbers. Yeah. So what happens is you get in the morning, probably starts at 5:30, 6 in the morning. You've got your people that are going to be out for that upcoming day shift, and you're trying to put your shift together. So what the chiefs do is in the, 6:20 in the morning or so, they send out a notice to all the stations to say it's a mandatory, I think they call it a mandatory recall. And what that is nobody can go home. Your relief comes in, they don't know who's going to get ordered or who's going to get stuck to work that, the next day. So if they were to let folks get relieved early, your relief comes in and you shuffle out the door, you're going, right? I mean, that's kind of the theory. So the chiefs come out with a notice across the stations to say it's probably done, and this is not in the complaint, this is me just assuming, it's probably done over the vocals in-house or even over the radio, to recall, captains can't go home, to recall engineers can't go home, or whatever the,
reliefs are terminated or reliefs are canceled.
Yeah, something along those lines to say, listen, and the reasoning behind it, I get it. They need to figure out, we know we're going to have to order so-and-so, so-and-so, and so-and-so to stay. And the only fair way to do that is to have them still be in the station, right? I mean, that's kind of where you're at. But what occurs when they do that is all of these firefighters that are in that class, and that if they say, engineers, no early relief, stick around. All the engineers now are staying beyond that 24 hours that they're in theory getting paid for. Mm-hmm. It's a very interesting, I kind of was expecting the lawsuit eventually on the late reliefs, folks coming from station to station, but there's a lot of factual issues with that as far as how the court's going to determine, because is that time compensable, where the firefighter that leaves station 5 to go to station 6, someone has to get paid for that time, right? Mm-hmm. But the question, I think the $1 million question, in this case, it literally could be $1 million question, is, is it the firefighter who, is traveling? Are they not entitled to pay because they're traveling from point A to point B? Because normally a commute is not compensable. So that makes sense. But now let's add the wrinkle of what if a firefighter is ordered to work from, that day. So that changes the dynamic significantly. There's a lot of moving parts. And I kind of expected that first lawsuit to kind of come along here eventually. The second one, the second argument being made here as far as the holdover, it kind of caught me out of left field with that one, but it makes sense. It does make sense. Somebody, if your boss is telling you, we use the example, sit in the corner, your relief is here, but you can go sit in the corner for the next hour. You can't leave. I get why the department's doing it. They have to do it to kind of fill the day. Mm-hmm. But at the same time, how do you not pay the person for that time? I don't know your thoughts on it.
Oh boy, I don't even want to disclose because I mean I've had to do that myself. Oh, yeah. And but I think if we take the 50,000-foot view of this, this is created because the fire department doesn't have enough people. Yeah. And that they're relying on overtime.
Yeah.
And so if you have an engine company and the engine company is staffed with 5, mm-hmm. but they run with 4. And you have those extra people, then you're probably not going to be in that situation. If you're in a situation where there is no overtime. Now, I know firefighters hate overtime, but they are addicted to overtime. It's like cocaine. Sure. And so they don't want to give it up. The city doesn't want to have to hire more people. So it's kind of like a match made in heaven. But when you don't have enough people, shift after shift after shift after shift, decade after decade after decade, okay, that this becomes endemic, you're going to have this problem. Yeah. And so I think from the management's perspective, put the FLSA aside, we need the ability to hold people, to make sure that we have enough, unless we're going to up staff. But if if that's off the table, whether it's, through collective bargaining, which usually the firefighters want the overtime, so they're going to say, okay, yeah, we should have 600 firefighters, but we're going to go with 500, and there's going to be overtime to fill in. Then you're going to be in that situation. From the shift commander's perspective, I've got to be able to hold these people, or else I'll be calling people at home till noontime trying to get somebody to come in and fill those spots. So FLSA aside, I think it's what they're doing in LA is probably what most fire departments, I've done it, most, fire departments are going to have to do. Yeah. But now we've got the FLSA part. And so I think fire departments are going to have to really rethink that and say, you know what, maybe we're going to have to minimize our reliance on overtime, because otherwise we're going to keep, think about how many people
growing.
Think about how many people are potentially impacted in the city of Los Angeles every time they put out that notice.
Yeah. And it was interesting in the allegations in the complaint, one of the plaintiffs, it made an allegation of this occurring, and I want to say it was December. It was right around the end of December. Mm-hmm. And the firefighter was at work it was either 72 or 96 hours that they were working. Their shift started on like a Monday morning. They came in at 6:30 a.m., performed the early relief. In theory, they should have gotten out on Tuesday at 6:30 a.m. Well, they didn't. They worked overtime Tuesday. Okay, that's fine. They worked the whole 24 overtime. They then worked, and if my memory serves me correctly, another 24. And then at that point, after working their third consecutive 24-hour shift at 6:30 a.m., their relief was delayed, and they ended up staying there till 8 in the morning. So in the allegations, not only are they saying you owe me 24 hours plus, this extra hour, an hour and a half, they're saying I worked 72, but you owe me 73 and a half. It just shows how it just keeps growing and growing and growing.
Yeah. I don't know. It'll be, this is going to, I think it's going to be precedent setting. Either way, they're either going to, and I can't imagine the courts are going to bless this and say you don't have to pay for that. I think
there's I don't see any way to do that, given the FLSA, given the regulations, even that early relief regulation that's premised there's 4 requirements that you kind of have to meet for the early relief to apply, and one is over a period of time it doesn't work. It doesn't occur where you're working uncompensated time. Do you know what I mean? Like if this happened once in a blue moon, not a big, like this happens. Like this is life. I think everyone kind of agrees with that.
Yeah. And I think you hit the nail on the head, where departments like, for example, Providence, where we were heavily dependent on overtime to staff the trucks, where, we should have about 125 on a shift, and minimum staffing was 98. Okay. Yeah. Where we start the shift, on paper with 92. So right off the bat,
you're hiring 6.
You need 6. Okay, right off the bat. Then you take 13 vacations and injuries and sick and everything. Now you're down in the 50s and 60s. You're going to hire 30 people back for a shift. That's the reality. And again, happens once, no problem. Happens a second time, when it's a daily occurrence, that's where I think the courts are going to step in and say you're going to have to compensate these folks.
Yeah. No, it's. I think that I agree with you. It's going to be precedent setting. I think it's something that we're going to. Yeah, I'm obviously following it. You're going to be following it.
Yeah, absolutely.
This will, in the hope, at least, we've always had that big. There's been a big question in the 4-day class as far as that commute from station to station. And we kind of debate that back and forth. If we have a one lawsuit that we discuss in the class where it kind of addresses it, doesn't totally. It's. And we kind of have said, well, what if the person relieved the other person? What if we kind of added our own little, I think that would have changed this. I think that would have changed that analysis. I think that for nothing else, this is going to hopefully give us a little more knowledge as far as where the lines are and how we can kind of set up our organization to kind of stay within those lines.
Yeah. And I think there's some solutions too, in terms of you can maybe target certain people. If the bottom line is you're going to have to pay whenever you do that, whether you do it once a year or you do it every day, but you target a smaller group of people.
Yeah.
And that's when you have the time, you can do that. And I know what was happening in my experience was guys who were cute they're going to say, you know, that they had a relief coming in at 5:30, or I got a substitute for some, whatever the excuse is. So they're going to get out of being ordered to work. So
absolutely. And I mean, like I said, I deal with a much smaller scale, but I mean, I've done that where you call the person who's on
same
the hook.
gene pool.
Don't
Same
go.
gene pool.
Yeah, can't go. I'm sorry. I'm still working on it, but your relief gets there. You got to sit tight. And typically 10 minutes later, you're calling them back saying you're all set, or you're calling back to say, sorry, bud, you know, you're staying.
Yeah.
So anyway.
Well, let's get to the last one. Okay. Right. And this one is another FLSA one. And this is, it's a question that came into me maybe a month or so ago. And I had it kind of on the back burner, and that the evening that I posted it, it just didn't seem like there was very much in the fire law news that night. So I said, oh, you know what, let me work on this. And 5 hours later, not 3 hours later, we have this post, and I've tried to edit it, tried to add some things in here on this, and Bill actually helped me out by explaining another part of this. It's almost like there's too much here to explain, but what we're dealing with is a question on part-time employees, not just part-time chiefs, but part-time employees, and whether or not we can take into account the fact that somebody's part-time under the FLSA. And if we take one big picture approach to this, the FLSA does not distinguish between full-time and part-time employees. They don't, it's basically the rules apply to everyone. So the context of the question here is it was submitted by a town manager who has a small volunteer department with a part-time fire chief. The chief receives a stipend, and the expectation is that they're basically half-time. They're basically going to put in approximately 20 hours a week, and the stipend is to compensate them for the 20 hours a week. The question goes on, he occasionally works more than that, sometimes more like 60, sometimes 80 hours a week. Is this particular chief an exempt executive like the police chief? Okay, the police chief is considered to be an exempt executive under the FLSA. They can be paid a salary, and they can work up to 168 hours a week, right? That's what we say, except once a year. Okay, you can work 169. But basically, exempt executives receive a salary, and they can work as many hours as the employer requires. So how about basically a part-time fire chief? And there's a number of parts to this that have to be considered. And number one, can a part-time employee fit under the executive exemption? And the answer to that is yes. Yeah. Okay, but you have to comply with all of the different aspects of the executive exemption, and probably the biggest one is going to be the salary. Yeah. They have to receive the same salary as any exempt executive, which is a minimum of $684 a week. They also have to qualify as receiving a salary, and that really goes beyond what we can really get into here. But you think about what does it mean to be paid a salary? Well, that's going to be part of the analysis here. But assuming that they are paid a salary, and assuming that it is at least $684 a week, which comes out to roughly $36,000, $35,568. Yeah. As long as they receive that annually, then yeah, they could qualify as an exempt executive. But it's the exact same test as a full-time employee. There is no special test for a part-time employee. So the next part of it, and there's, besides the salary test, there's also a duties test, which is what is your principal activity? What is your primary duty? And, it is. I would think any chief of department, their primary duty is management of the enterprise. Yeah. Okay. So they're going to probably qualify under the duties test. So the salary test is going to be the biggest challenge. The next thing is there another way to characterize the relationship? And there is. You could be right. You could be a volunteer, and as sort of a nominal fee for serving as the fire chief, we're going to give you this stipend. And the maximum amount that could be given under this would be 20% of what it would cost for you to hire a full-time chief. Okay. But mindful that you're talking about a full-time chief, we've got to compare apples to apples. If a full-time chief would cost you $100,000, you've got to look at a half-time chief would cost you $50,000. So you've got to go 20% of $50,000, not 20% of $100,000. Yeah. I don't know if hopefully I explained that part of it. It might be a little bit confusing.
It's a tough area. And this is a common, this is a common challenge for fire departments, for cities, or towns, small towns in particular, because you do have a person that was, probably was a volunteer. It's probably, this type of organization might be a volunteer organization, right? But you need someone to be in charge of it. And obviously it's more than what you can expect out of exactly as a volunteer,
without something to incentivize it.
Absolutely.
So,
and there are a number of, go ahead.
Yeah, no. So that's sort of the next option. If you can fit within you, if you're not up to the salary level to meet the minimum for the exempt executives, you may be able to categorize the relationship as a volunteer with a nominal fee. Yeah. If you don't pay enough to meet the executive exemption, you pay too much
for it to be a nominal fee,
which I think is where many fire departments are.
Yeah.
Okay.
Absolutely.
They're an hourly employee, even though they meet the duties test, even though they are the fire chief and they could qualify duties wise as being exempt executive.
They don't make
enough money. Got to treat them as an hourly employee. Yeah. And that means you need to pay them. Now, you don't need to pay them more than what you're paying them because they work 26 hours, 27 hours, 28. But once they go over 40 hours, you're going to have to pay them.
Yeah.
Overtime.
In theory, if it's a private entity, mm-hmm. If it's a public agency, you could have a little more, you could avail yourself to, like we were talking about earlier, the 7K exemption, or mm-hmm. potentially the small fire department exemption, possibly, depending on the circumstances. Right. So those are two options that you discussed in the article, and then I kind of picked up and discussed the other option, which I think the best option is that executive exemption. Like that's obviously, I think if you can make it, that's the way to go.
But let's go back, because what Malcolm's going to do is Malcolm's going to break these videos up, and so people who are listening to this may not have heard our earlier conversation on the small fire department exemption and the discussion on public agencies.
All right.
So go ahead. You want to jump in on public agencies?
The FLSA contains special rules that are only applicable to public agencies. And the biggest ones, or the three biggest ones, are comp time, which we're not talking about here, 7K exemption, which is for most firefighters, when most firefighters don't receive overtime after working 40 hours every 7 days. They're going to receive overtime after working 53 hours in 7 days, or in some instances, 212 hours in 28 days. And I know some of you will be familiar with this. Some of you might be, whoa, what's up with that? But that's the special rules in the FLSA related to, fire and law enforcement personnel. The Congress carved out these rules to kind of help these public agencies, cities and towns deal with the impact of the FLSA. Now, who qualifies as a public agency? Most municipal fire departments certainly do. County fire departments, fire protection districts, the ESDs. I know some ESDs down in the Texas area, region. They have those emergency service districts. Who does not qualify as a public agency? It's typically going to be that volunteer fire company, like a 501c3 type of an organization that's really not, and they don't answer to the general public. That's kind of the rule there. So if you are a public agency, you can take, you can use these provisions of the FLSA to kind of minimize your overtime obligations. And in those instances, if you're a public agency, you could say to this chief, you're not going to get any overtime until you work 53 hours a week, as opposed to the 40, the general rule.
And then the last option there, next to the last option there was the small fire department exemption. And that's if you have less than 5 firefighters, or less than 5 employees in fire protection activities. We got to be specific here. Okay.
Yes.
So employees in fire protection activities. So there's actually one more. And if you take a look at my blog, you'll have a link to go back to Bill's blog, and Bill explains that. And I know we're getting up to about 50 minutes here, so we want to kind of move through it quick, Bill. But fill us in on that last option, the fluctuating.
Fluctuating work week. And basically what it is, and it's the second best option here next to the executive exemption, in my opinion. And it is especially for that non-public agency. You paid a salary, and that salary represents compensation for all the hours that you work that week. Now, if you're entitled to overtime, the overtime is actually computed at halftime, the half of the regular rate for each work week. And you calculate that regular rate anew every work week. So it's really, and I give an example. The best way to explain it, in my opinion, is through example. I know I put an example on my website of, how that works. So basically the regular rate is calculated every week. You still get overtime at the end of the work week. You're still going to get overtime if you work more than 40 hours, if you're that private agency, or more than 53 hours if you're that public agency. But the overtime rate is less than the traditional time and a half. It's not. But it certainly, technically it's not, because the salary is paying you for that straight time component of all the hours that you work. That halftime is just the additional that you're owed. So it's a unique provision. It's not an exception. It's not an exemption. It's just another way to pay folks. And it's the best option for those public agency departments that are wrestling with this issue where they can't meet the executive exemption.
Let me see if I can kind of summarize the fluctuating work week. I'm going to give it a try because it's not easy.
It's not easy.
Essentially, you as an employer, you can hire someone and give them a salary, and that salary can cover all of the hours that they work. Okay, so let's say I want to pay somebody $1,000 a week, and if they work 20 hours in a given week, they get $1,000. They work 60 hours. Well, maybe not 60. Let's say 45 hours. Okay, they get $1,000. It's supposed to include whatever hours that they work. Okay. Now, in order to qualify for that, you have to be working fluctuating hours, where it's difficult to sort of determine ahead of time exactly how many hours somebody's going to be working, which, you would think a fire chief, they may have a city council meeting to go to. They may have this to go to, that to go to, runs and different things, may be difficult. So the fluctuating work week could be. Now, one of the drawbacks, if you pay them $1,000 a week, you're going to qualify for the executive exemption, so you wouldn't need it. So it'd have to be somewhat less than that. But what can happen is if you work too many hours, the fluctuating work week, that salary doesn't compensate you enough. And you actually can have a minimum wage violation. That's one problem. The other problem is once you work over 40 hours in a week, the person is entitled to some compensation, maybe halftime, could be time and a half. It depends on how much you're paying them, what happens when you divide whatever you're paying them by 40 hours in a week. If that drops them down, or however many hours, if it drops them down below minimum wage, you're going to have to pay them time and a half. So it's a complicated thing. I think Bill does a really good job of explaining it on his blog. So certainly those who are, they were confused when Bill explained it, and they were even more confused when I explained it, will be unconfused after reading Bill's post about it. Okay. But it's
very difficult to explain. Curt did a better job than I did. That's for sure.
Well, one of the things that I found about the FLSA, there's a difference between simple and easy, okay, and hard and complicated, okay. Losing weight is simple, but it's hard, okay.
Yeah.
Understand the FLSA is complicated, but it's relatively easy. Like once you understand it, it's really not that hard.
No.
Okay.
You can break it down, and you break it down into pieces, and you just kind of work your way from there. You're right.
Yeah. So for those of you who, the explanation might have been a little bit more complicated, we've got a couple of programs on this that can help get you to the point where you understand. Like, I think if you understand the why why is the FLSA written in the way it is? Why does this work this way? Then it's easy. But you got to get through that sort of complicated part of it, and then the rest of it is fairly easy. It's not like losing weight. Okay, losing weight is right. It's simple, right? But it's hard.
True. Very true.
At any rate. Well, Bill, that's going to wrap it up for another week of Fire Law Roundup. Thank you for pinch hitting. I'm sure we're going to see you again on here pretty soon. And to everyone, please, if you haven't already subscribed to our channel, please subscribe. We're almost at 1,000 subscribers, which is a big deal for YouTube purposes. So please subscribe. Please click like, and we'll see you again next week. All right.
Thank you.